So the Supreme Court, in the rulings that they've made in the past, they basically have made laws, their rulings have basically permitted laws that effectively prevented black males from voting in southern states. Yes, the 15th Amendment went ahead and protected the right to vote, but what they did was, by going ahead and allowing the states some leeway, the southern states continued to go ahead and prevent blacks from voting, but they just did it in a more creative way. So instead of enslaving people, they had literacy tests. If you walked up to go ahead and vote, what they would do is they would say, you need to go ahead and you need to take this test and read this document, and if you can read this, you can vote. Well, a lot of southern whites couldn't read as well. But they would say, oh, there's a thing. If your grandfather voted in this district, you don't have to take the test. If your grandfather didn't vote, you have to take the test. Well, the whites' grandfathers had voted, so they didn't have to take the test. Did the blacks' grandfathers vote?
No.
Why not? They were slaves. They couldn't vote. And so they would be denied the right to vote, and their kids would be, and their kids would be, and so on. They also did poll taxes, where you would come in and you would have to pay a certain amount to go ahead and vote. Now, this excluded anybody who was really poor, but blacks were extremely poor, and so they were prohibited from going ahead and voting effectively by going ahead and saying you have to pay to go ahead and vote. Just so you know, when we think about civil rights and we think about the progress we've made in this country, and there's been some progress, it wasn't until 1964. Now, that seems like years and years ago to you, but I was 6 years old when they finally banned the use of poll taxes. When the court, when we changed the Constitution and said, this is unconstitutional, you can't do poll taxes. So the attempts to go ahead and remedy some of these problems has actually been relatively recent, and it's pretty easy for people to forget about that it has been relatively recent, that some of the progress has been made on these issues.
Now, I got a quick question. On the, when we go back to the literacy test, do we need to know about the grandfather clause?
It's useful to know.
For the test?
Yeah, that's useful to know. Matthew.
So the 24th ban exclusively poll taxes, or just anything that would prevent that from voting?
I think it's specifically poll taxes. It bans any kind of poll taxes. So I want to talk specifically about the courts and civil rights. But I want to talk about something that's a little bit complicated, but since we've covered the judiciary now, I'm hoping that it makes this a little easier to understand. Part of the reason, if you noticed in the book, civil rights is dealt with at the very beginning. And we don't talk, and they don't introduce the courts until much later. I think that's kind of backwards. So that's why I think it's important to know about the courts before we talk about civil rights. So that's why civil rights, the way I've laid it out, comes afterwards. When a citizen goes ahead and wants to challenge a law that limits the rights of one specific group but not others, the judge, when he's hearing the case, basically gives the law a test. So if there's some law that's been passed, and let's say it treats blacks and whites differently, or women and men differently, or young people and old people differently, or gays and straight people differently, right? If there's a law that limits the rights of one group but not another, somebody can sue, and what the judge will do is essentially give the law a test to see whether it passes or not. If the law passes the test, then it's constitutional. If the law doesn't pass the test, then it's unconstitutional. Okay, so the judge is going to basically test this law, give it a test, and see whether it passes or not. And there are 3 tests that the courts use. And I want to talk about each one of them individually. The first test is called the strict scrutiny test. The strict scrutiny. So what does scrutiny mean? When you scrutinize something, what are you doing it? What are you doing?
Looking at it under a microscope?
Yeah, you're looking at it very closely, looking at it under a microscope. So strict scrutiny means you're looking at it very closely. This is the strict scrutiny test. So the judge is going to look at it very closely. If the government passes a law that treats people differently based on race or ethnicity, and ethnicity is national origin, where you were born, To pass the test, here's what the government has to prove. For a law to pass the test, the government has to prove a couple things. First, that there's an important reason for treating people differently. There's a very important reason for treating people differently. And we go ahead and there's a word that we use, a phrase that's used all the time in the courts to refer to these important reasons. It's called compelling interest. The government has to demonstrate that it has a compelling interest in going ahead and limiting and treating people differently. That's a phrase that you're going to hear many times, both today and then when we talk about civil liberties. Compelling interest. What does that mean? If I say the government has a compelling interest, what does that mean? Just that they have a really important reason. An important reason for treating people differently. Next time we're going to talk about when the government places limitations on our freedoms. And I'm going to tell you the same thing. What the courts say is in order for the government to limit our freedoms, they have to demonstrate that they have a compelling interest, an important reason for limiting our freedoms. Like, for example, we have freedom of speech, right? Can we go ahead and go into a theater and just walk in and go, fire, and run out? No, we're not. We can't. Why not?
There are certain areas where you lose your freedom of speech, like in schools.
Right.
Yeah.
But I would suggest that it's not so much that you're in a place where you lose your freedom of speech, because you could walk in. Could you walk in and say, the government sucks? You know, President Obama is an alien. You could walk in and scream all that. You wouldn't be arrested. You might get mugged by the crowd. Dude, I'm trying to watch a movie. Right? The reason that the government can limit that is because they have a compelling interest in preventing that kind of speech. What's their compelling interest in that case? Pardon? The safety of the people in the theater. Absolutely. So the courts have said, okay, in a case like that, you can limit somebody's freedom of speech because you have a compelling interest, an important reason for limiting that kind of speech. So this notion of compelling interest, we're going to talk about a lot. So, to pass this test, they have to first demonstrate that there's an important reason, that the government has a compelling interest in wanting to go ahead and treat people differently. Second, they have to go ahead and demonstrate that the law as written affects as few people as possible. You're going to treat people differently, and you've demonstrated you've got like an important reason that you have to do it. You have to write the law in such a way that it affects as few people as possible. And then lastly, there has to be no other way to get done what you want to get done. All three of those things need to be met in order for a law that treats people differently to survive the strict scrutiny test. So, for example, when busing first started, do they do busing now? Is there any busing in your guys' schools? Yeah? Who's bused where? Do you know?
Mine was bused to La Mesa.
Where's La Mesa?
The training country,
Oh, okay.
I think.
And what school did you go to?
La Mesa.
Oh, you went to La Mesa. What was your home school?
Arroyo Seco.
And could you have stayed there, or was it mandatory? You had to be.
Yeah, I was capped, so I couldn't go there.
Oh, because it was full. So it wasn't for the purposes of integration or anything.
Oh, no.
Oh, okay. Do they do busing for the purposes of integrating? Yeah, because when I was a kid in junior high school, that's what they started doing. They started integrating people. So kids from South Central LA were bused into the San Fernando Valley, right, to create integration, right, of the races. I would say it was not a good experiment. It didn't go well. But I understand what they were trying to get done. But that's exactly the kind of thing that the courts permitted. They would say, yes, there's an important reason for treating people differently, for requiring blacks to go ahead and come to the schools in the valley. Because the courts have said over and over again that diversity in schools is an important thing for the government to do, right? The law affects as few people as possible. Only a few people were bused. To get this diversity in schools, there was no other way to get it done. And so these kinds of laws survived for a while at least. Now they're not doing it as much. That's the strict scrutiny test, right? You got to meet 3 standards. This is the hardest test, the hardest of the tests to pass. Whenever you want to go ahead and treat people differently on the basis of race or ethnicity, the courts are going to look at it very, very closely. These cases come up frequently. They still come up frequently, especially with college applications. There are schools that allow points, extra points, if you're black, or if you're Native American, or if you're some other unrepresented group. And so there have been a series of court cases dealing with this. The next level